Okay, good. So, welcome everyone. We start with the webinar today on Mediation Act 2023. It's I would say, wonderful topic because this is a very, very recent act. It's the first sort of mediation law passed by the country in a very structured, formal format. And this is as recent as 15th of September. It received its President assent on 14th September and got notified on 15th September. And the sort of first set of notifications notifying few sections to be operational came on just 10 days back, which is 9th of October 2023. So this is a very current topic, very important and pertinent topic, especially for, I would say, litigators. But in the same breath, I would say also for the mediators, arbitrators, and also for the company, for the professionals inside, means the in-house counsels, CFOs, CEOs, MDs, for as a great remedy for alternate dispute resolution. So I would like to start with a preamble of the act. An act to promote and facilitate mediation, especially institutional mediation for resolution of disputes, commercial or otherwise, enforce mediated settlement agreements, provide for a body of registration of mediators, to encourage community mediation, and to make online mediation as acceptable and cost-effective process, and for matters connected therewith or incidents thereto. So I think the preamble is beautifully written, covers the essence of the whole Mediation Act, and therefore we have today Advocate Varun Sharma with us. I'd love to introduce Varun. Varun is a principal associate in the legal vertical at eMinds Legal, which is a corporate law firm. Varun has over 8 years of experience in corporate and commercial litigation matters and has handled diverse matters related to company law, insolvency and bankruptcy law, white collar crimes, debt recovery, etc. And Varun has been instrumental in facilitating a lot of mediations and settlements himself, and that's why his sort of grip or involvement in the subject, and also is involved in several arbitrations. So welcome, Varun, to the webinar.
Thank you so much, Sumit. Thank you.
Yeah, and as an introduction, I'm your host, Dr. Sumit Pahwa. I'm a corporate lawyer and company secretary with 25 years of experience. And I'm currently the co-founder and CEO of Complinity, which is India's leading compliance software, helping companies comply with the laws of the country. Complinity covers 2,000 plus laws and a checklist of over 25,000 compliances updated on a daily basis. And Complinity is adding value to 1,000 plus companies, 10,000 plus users spread across 50 plus industry verticals, and organizations like Panasonic, Max Hospital, Roy Hotels, Toyota, Yes Bank, British Council, and many more are using Complinity for their compliance management. So this is a brief about Varun, myself, and Complinity and eMinds Legal. Varun represents eMinds Legal, I represent Complinity. Jumping onto the topic, we have the background now. It's just as a cadence, it's a open conversation format. There is no PPT, no presentation, so we won't really bore you for that. It'll be more conversational, and I'll ask a few pointed questions to Varun. And in the meantime, if you have any questions, you can also put it in the Q&A box, and we will surely take all the Q&A as well. And this is 12:09 by my watch, and we will try to finish it on or before 1:30 p.m. today, so that we all can have a sumptuous lunch after that. But the intention today is that, it being a new act, some of you may have read it, many of you may have been practicing it as well. I mean, not in the form of act, but in form of mediation and settlements that you might be forging. But today it is to uncover the aspects of the Mediation Act, to see what are the opportunities, what are the challenges, what are the gray areas, if any, and if there's any Q&A or if there are any questions which you have, we'll attempt or seek to answer that. So please keep putting your questions in the Q&A box, and we will see. We will take the Q&A. I, as a moderator, will take the questions either in between or towards the end. We'll see. But just before we jump onto the sort of discussions, I would love to have a small poll just to get a sense of the audience. So here I launched the poll. If you could just give your answers very quickly. What describes you best? Are you an in-house legal, like a general counsel, or an in-house legal team, or a company secretary? Or are you a practicing advocate? Or are you a practicing chartered accountant, company secretary, cost accountant? Or you represent other functions like finance, HR, IT, admin, and other functions in a company? And have you experienced any mediation yourself? So this will give Varun, especially, the idea of the audience. And Varun, you can be either more technical or less technical, depending on how you see the audience. Okay.
Yeah.
We'll wait for 30 more seconds before we sort of jump onto it. Okay, very quickly, if you could, others can just put in their answers. 10 more seconds. Okay, I'll end the poll and share the results. So it's a good mix, I would say. 38% in-house and some advocates, some practicing finance. And yes, 44% have experienced mediation and 56% haven't. Okay, so that's a good mix. Okay, Varun. So now my first question, Varun, to you is, I think let's start with the concept itself. Would you like to describe to the audience what is mediation? We're talking about Mediation Act 2023. So why don't we start? What is mediation?
Okay, Sumit, mediation is where two parties to a dispute, they decide on a name of a neutral party, which is now a mediator, to help them resolve their dispute amicably. That's it. That is what a mediator is. Now, as per the definition, as per what has been now given in the Act, because with the Act, Mediation Act 2023, mediation now also includes pre-litigation mediation, online mediation, community mediation. So the same concept will apply everywhere.
Right. But Varun, mediation is not a new concept. Means we have heard about mediation, and mediation has been happening over so many years. Generally, in in court mediation centers, and otherwise in so many other specific legislations. So, what is so new about it, and why this act was required as such in the first place?
As you have rightly said, Sumit, mediation is not a new concept. The earliest description of mediation comes in CPC, the Civil Procedure Code, where the process of alternate dispute resolution mechanism was there. And then we can, with the time, we have seen the process of mediation coming in different acts like MSME Act. We have seen it in consumer protection also. Now, since we have the concept of mediation in different laws, this act was Mediation Act 2023 was then required to collate everything and make a proper procedure out of it. So therefore, this act was there. This is in my opinion, also this is a very beautiful legislation, and this is going to help the legal industry in a much better way.
Right. All right. Okay. Now, coming to the slightly details. So, Varun, would you like to explain what is the applicability of the Mediation Act 2023? To whom it is applicable, and what kind of disputes are covered under the Mediation Act?
Okay. If we talk about the applicability only on the mediations that are done in India. The application is covered under Section 2 of the Act now. So all the mediations done in India will be covered, and for those mediations, any of the parties, both the parties have to decide on a name of the mediator, as I stated earlier. And apart from that, mediation agreements is now a concept where if it's a detailed agreement in itself or a clause in form of an agreement that can be added, applicability will arise from there. International mediation is again there.
Right.
Yeah.
Mm-hmm. And
even for sorry.
Yeah. Go on.
Even for as per Section 2, we can also see that wherein one party of the dispute is central government or state government also now has been given the authority for mediations and all.
Right. So, and what kind of disputes can be referred to mediation? Means, what disputes are we talking about?
If we talk about the Act, all disputes can be referred to mediation except the disputes that have been specifically mentioned in first schedule, which is coming from Section 6, if I'm not wrong. Yes, Section 6 disputes. So these disputes are for example, criminal prosecutions, disputes related to telecom industries.
What cannot be? What cannot be referred? You're giving that description, right?
Yes. What cannot be referred? Yes.
Can
so anything apart from that is covered. So what cannot be covered is criminal prosecutions, criminal proceedings, dispute relating to telecom industries, Competition Commission of India, electricity tribunal, electricity issues, SEBI, NGT, taxation matters, non-commercial disputes, and specifically, like for us, any issues with the statutory bodies for professional misconduct, like for lawyers, for company secretaries, for chartered accountants. Those are not covered under mediation.
Right. And so I'm also referring to the first schedule, which covers all these matters, what you just mentioned. The first clause says disputes which by virtue of any law for the timing in force may not be submitted for mediation. So I think if there is a specific law for a subject which deals with that matter, and it specifically prescribes a dispute resolution procedure, then that cannot be submitted to mediation. All other disputes, right? And the examples you gave are also mentioned in the schedule is criminal and NGT and Competition Commission and TDSAT, etc., SEBI, tribunal, etc. Right?
Yes.
So in essence, can we say that all other commercial or civil nature disputes can be referred to mediation?
Yes.
If criminal is outside and some specific legislations are outside, can we say that all other commercial disputes arising from agreements and all other civil disputes, even if it's matrimonial disputes, they can be referred for mediation?
Yes.
Right. Perfect. That clarifies. Friends, if you have any questions on what we are discussing, or anyways, if you have any questions on this act, please keep putting in. I'm seeing few questions already. Keep putting your questions. I'll be taking up the Q&A in between or towards the end as well. Okay. Now, so having talked about, Varun, what is mediation and the applicability of mediation and what disputes are covered, if you could articulate who can be a mediator and what is meant by a mediation service provider as envisaged in the Act.
Okay. A mediator, as per the Act, a mediator can be anyone who is empaneled as an individual decided between the parties. Any person who has now been decided between the parties to act as a mediator, that can be a mediator. Anyone who is empaneled with the Mediation Council of India, which will be established under this Act, will be a mediator. And anyone referred by the mediation service provider will be a mediator. So as your the second part of your question, what is mediation service, or what is exactly a mediation service provider? It's an entity now that will be given recognition under this Act, who will be given authority to empanel mediators and who will help parties to approach them in case of any dispute wherein they are unable to decide or single on a name for a mediator. You can parties will be able to approach the mediation service provider for appointing a mediator, basically.
Right. So I think it's a new concept envisaged under the Act of entities being corporates, which would be registered as mediation service providers. So I think I'd like to draw an analogy with in the insolvency law, when the IBBI as a regulator, insolvency professionals as a creed of professionals, and insolvency professional entity as an entity which has a lot of insolvency professionals. So I think similarly here also the similar concept is being propounded, that Mediation Council of India, which will be like a quasi sort of regulatory body here, mediation, and they will accredit either mediators who will be like qualified professionals, and they may come up with some rules or something of the qualification, experience, etc. And then mediation service provider being entities who will have a lot of mediators on their panels, more like an institution. Right? So this will pay for institutional mediation also, other than ad hoc mediation, just like arbitration concept also, right?
Yes.
Right. Understand. Okay. And what if the parties are not able to zero in on the name of a single mediator, like in arbitration? So I'm drawing quite a lot of parallels actually from arbitration. In arbitration, there is a ad hoc arbitration, institutional arbitration. There's a concept of one arbitrator, three arbitrators, and more odd numbers, etc. So in case of mediation, I'm trying to draw a parallel, Varun, that if the parties are, you said mediator is somebody which the parties appoint, or you go to a mediation service provider for referring a mediator. So MSP is an institutional mediation that is understood. Means similar to institutional arbitration that might function according to the rules of that MSP, etc. But in case of ad hoc mediation, if the parties are not able to zero in on the name of a single mediator, then how will the mediators be appointed? And how many mediators? Can there be more than one mediator? Does it have to be even number, odd number? What is the rules around that?
Okay, the Act currently, since we are still awaiting on specific regulations and rules which have not come out yet, the Act is currently silent on the fact that what will be the procedure in case the parties are unable to fix on a name. However, with the establishment of Mediation Council of India, this is what I believe is, in case the parties are unable to fix on a name for appointing a mediator, the parties will be allowed to approach the Mediation Council of India to appoint a mediator.
Yeah, yeah. I could catch you when you said medical council, yeah, because the names, the acronyms are very MCI,
yeah.
that is Medical Council of India. This will be Mediation Council of India. So I understand
Yes.
the concept. Yeah,
Yeah. My apologies.
No, that's okay. As a moderator, my job is to sort of also catch you, just on a lighter tone. Okay. Next is that if you could now talk about the mediation agreement, since, while describing initially, you said that mediation will be which comes out from the agreement. So if you could talk about what are the, what is mediation agreement, and can it be like a clause, or does it have to be a specific agreement, and something, anything that you'd like to share around that? Yeah.
Okay, so for as far as mediation agreement is concerned, that agreement can be a separate agreement to a commercial transaction also. Parties entering into a commercial transaction can then have a separate agreement to specify all the details of the mediation. As we have seen as a practice, most of the commercial agreements already have a dispute resolution mechanism in it. And out of those, most have the arbitration yet, because this is a new concept. So arbitration was always there. In case of any disputes that arises between the parties will first try to, in the similar language, the parties will first try to settle the disputes amicably through negotiations and etc. And if they are unable to do so, then they can approach they can approach the method of the arbitration. But as far as the mediation now is concerned, so mediation agreement or mediation clause in a specific agreement will mean the same thing. Like the arbitration agreement and the arbitration clause in a particular agreement means the same thing. This will also mean the same. This will also mean the same thing.
Right.
It will have to be mutually agreed between parties. Where the mediation will happen, what rules will, whether it will be an institutional one or an ad hoc one. So that will be decided, and everything will be noted down. So this is what will will form part of the mediation agreement or the mediation clause in a particular agreement.
So what you're saying is that either means it can be a mediation agreement, just like an arbitration agreement. It can be a mediation agreement. And
yes.
Did you say that can it be a clause also other than the agreement?
Yes, a mediation clause, definitely. Like you add an arbitration clause for dispute resolution in a commercial transaction or any kind of a commercial transaction. So we will see draftings of mediation agreements, mediation clauses also now in the same agreements.
Okay, and so do parties have to mention the name of the mediator in the agreement itself or the clause itself?
Well, that's not necessary, because as we have, I will draw my attention. I will draw my explanation and conclusion from what we have seen in arbitration. It is not necessarily required to specify the name at the time of execution of the agreement. The parties can simply decide that in case of any dispute, one party will maybe may assign a name, and the other party can agree or not agree. Again, we go back to the same thing. If the parties don't agree, then the mechanism of whether approaching to the Mediation Council of India or specifying the name of the mediation service provider, so that we still have to see. But yes, it's not necessary that they have to specify the name of the mediator in the mediation agreement or the mediation clause.
Yeah, but what is interesting to note, Varun, is that in case of a ad hoc arbitration, if the parties are not able to zero in on a single name, then they have to approach the high courts to get an arbitrator appointed, which may appoint from an arbitration institution, from a panel of judges, or otherwise. But in case of mediation, I think everything, all the shots will be called by the Mediation Council of India, right? If it is not named, then Mediation Council of India may sort of appoint an arbitrator like that, right?
Apart from this, yes, I agree with this. And more than that, in order to add, there is also the appointment of the appointment of a mediator is specifically also mentioned in the Act. It comes from Section 8 of the Act, which is there. So who can be appointed as a mediator? So it has to be a person of any nationality can be a mediator. It's not necessarily required to be an Indian person from Indian nationality. Or the parties can freely decide who can be a mediator if a mutual name is consented by both the parties. And if parties don't reach to an agreement, then yes, the party seeking for mediation shall file an application with the mediation service provider or the Mediation Council of India.
Yeah, or else talking about institutional mediations in future. And if we, for example, are able to see some good mediation service providers being body corporates who have registered themselves as such as an MSP with the Mediation Council of India, then I think just like we put institutional arbitration clauses in agreements, like these disputes will be subject to DIAC or SIAC or LCIA, like in international arbitrations, or like Delhi or Mumbai Center of International Arbitration, etc. Similarly, I think we might be able to, or parties might be able to include certain MSP names if they become really do good service and if they become good names in mediations. They may
Yes,
put those names in the agreement that in case of a dispute will be referred to this mediation center, and then that mediation center rules and bylaws will take over and appoint the mediators, right?
Correct. Yes.
Right. Understand. Good. Okay, and since we're talking of agreement, mediation clause or mediation agreement, can there be oral mediation agreement, Varun?
No, it has to be a written agreement. It has to be an agreement signed by both the parties and mutually agreed. So agreement in itself has to be written. Obviously, there are oral agreements, but if you orally decide on someone, then you can very easily agree it was never decided. So as per the Act, it's required to be written, a written signed agreement.
Right. And if suppose there is no mediation clause in an agreement, or there is no mediation agreement per se, and the dispute occurs, and at that juncture the parties intend to refer themselves to mediation, can it be done?
Yes, it can be done at that point of time also. Unlike arbitration, again, arbitration has to be pre-decided. Like as you asked, arbitration has to be pre-decided for the for any dispute or commercial transaction. For mediation now, it's no more necessary. Parties who have not previously agreed for going for the mediation under this Act, in case a dispute arises, the parties can still approach, one party can initiate and give its consent or give its intimation that they want to initiate a dispute resolution mechanism under this Act. And if the other party agrees, then yes, both the parties can file for with the service providers or the council of the mediation council for the appointment, or appoint any single one also.
Yeah, unlike arbitration, where the existence of a clause or an agreement prior to the dispute is essential for parties to refer to arbitration. Here, even if there was no clause or no agreement, however, even after the dispute has occurred, and if both the parties consent, I think the key word here is both the parties consenting to subject themselves to mediation, they can refer the matter to mediation, right? And that's, I think, one of the key differences. So since we are okay, one more thing on the agreement itself. So I think in this online era where everything is happening online, can the if the consent of the parties subsequent, suppose there was no agreement, no clause of mediation, can the parties consent on email exchanges or emails that okay, we would want to subject to mediation? Will that be construed as a mediation agreement?
Yes. I should have mentioned it earlier also when I was explaining it. Now, electronic communications will also be treated as mediation agreements or acceptance of going for mediation. Exchange of emails will very well be included in the same. Yes. So even if
please proceed.
Even if the parties have not decided priorly that they will resort to mediation under the Mediation Act, then yes, if the dispute arises in future or at any point of time, then yes, on email also, if it is decided, then yes, it is a mediation agreement.
Right. Well, that's quite a welcome step because everything is going online, and this is quite less in procedure, I would say, to that extent, quite relaxed in procedure.
Yes.
And therefore enabling or facilitating mediations. Yeah, clearly. Okay. Now, since I think we've been drawing parallels with Arbitration Act, Varun, since beginning, I think it will be very, very apt, and I think it may be a question in the minds of other people as well, the audience, that if you could articulate the key differences between an arbitration and a mediation, since there are quite a few similarities as well. Both are alternate dispute resolution mechanisms. So, what are the essential differences between an arbitration and a mediation?
Okay. First and foremost, the terms itself, the arbitrator and the mediator. An arbitrator, a mediator basically acts as a facilitator to resolving the disputes. However, an arbitrator is more of an adjudicator of the issue. The mediator will not necessarily go into the merits of a case. However, the arbitrator will specifically go into the merits of the case, will go through the evidences, will go through the documents. The mediator will not do that. So mediation is more of we can draw the same attention. It's more of a little informal structure wherein the parties are only sitting and the mediator is facilitating for settlement of the win-win scenario, settlement of the issue. However, as for the arbitration is concerned, arbitration is where one party wins and one party loses, because it's nothing but it's a concept of court only, where a judge or the arbitrator having the authority of being the adjudicator, the judge who judges the complete scenario on merits and then passes an order. However, in mediation, it will be a win-win situation for both the parties. The mediator will facilitate the mediation, will push the parties to reach at an amicable solution, reach an amicable solution, and then get the mediated settlement agreement drafted.
Right. No, absolutely. Varun, but if somebody has to facilitate a settlement, as lawyers, even as litigating lawyers, one of their jobs is, of course, to initiate settlements, to negotiate settlements, etc., even while they are litigating. And I think one of the good results which comes out of a litigation also is a settlement, which is a win-win, which is a win-win. So while the case is going on, then nothing stops the parties or the litigation counsels to sort of talk, sit together, and negotiate a settlement agreement. So if all that can anyways be done in an informal context, settlement agreements can be drawn and agreed, then why this act is required? I go back to the first question: why this act is required? I mean, settlements is not a new concept, and are we teaching how to settle to the lawyers or what?
So, Sumit, if I understand it correctly, you're basically asking me what is the difference between a regular settlement agreement and a mediated settlement agreement?
Maybe that's what I want to ask. Yeah.
Okay. So a regular settlement agreement is a contract. When the parties, if it's not under this act, if it's a regular settlement agreement, the parties who have now reached a settlement, they sign a contract, and that they sign an agreement that becomes a contract. However, as far as the mediated settlement agreement is concerned, under the Mediation Act 2023, mediation settlement agreement will be a judgment. So it will no longer be something where if someone wants to oppose or challenge the settlement, it will go back to the merits of the case. No. So for an agreement under the Mediation Act 2023, a mediated settlement agreement will be treated as a judgment passed by the mediator.
Right.
And the same can be again enforced through the same provisions of CPC as in arbitration.
Right. That's interesting. So what you're saying is that in case of a normal settlement agreement, historically, when parties were litigating and lawyers were negotiating settlements, and they draw up a settlement agreement on stamp paper, notarized, this, that, if that breaches, if the consent terms or a settlement agreement breaches, you would have to approach the civil courts or whichever court of jurisdiction.
Correct.
For breach of that contract, right? Breach of settlement agreement or contract. However, in this case, you are saying that in case of a mediated settlement agreement under the Mediation Act, it will be as good as a decree. Once a settlement agreement is reached, it will be as good as a decree. And therefore, if there is a breach, then you'll have to go for execution, probably, right?
Yes.
As an execution proceeding.
Yes. So with the regular settlement agreement, parties go back to litigating. With the mediated settlement agreement, parties will go for execution.
Right. Oh,
and yes, and as far as the challenge is concerned, there is a specific section which talks about challenge of the mediated settlement agreement also, but it's very, very limited. It's very limited to fraud, corruption, or undue influence, and if the matter that was basically mediated forms part of the first schedule under Section 6 that we just discussed previously.
Welcome to Complinity Technologies. Complinity is India's leading governance, risk and compliance software helping companies to manage their compliance, contracts, litigation, legal updates, inter-financial controls and more. Complinity is a one-stop shop for all GRC needs. With our proprietary 12 GRC modules and real-time legal updates on 2,000 plus laws and 24,000 plus compliances. All in an integrated platform that is easy to use with automated alerts and risk management capabilities. Is why compliance managers, general counsels and chief financial officers choose Complinity every time. Join the most innovative and prestigious brands that use Complinity. Automating your compliance management. Request a demo at complinity.com.
So it's a very limited grounds for challenge also. So for a mediated settlement agreement, it won't be further litigation. It will be execution only.
Right. No, wonderfully articulated the difference, I think. And also, Varun, the Arbitration and Conciliation Act has been there. And while, of course, it has been doing a good job for arbitrations, the conciliation as a concept or as a matter has not really been so used, or at least at least in my own experience, I haven't really seen too many conciliations under the Arbitration and Conciliation Act per se. So if you could articulate the difference between now the Mediation Act and the conciliation of the Arbitration and Conciliation.
Okay. Sumit, I would say mediation is a kin of conciliation only. So as for the Arbitration and Conciliation Act, conciliations definitely, even very few people actually go for conciliation under Arbitration and Conciliation Act. But with the coming in force of Mediation Act 2023, as a part of the original act that has now been released, the conciliation sections from the Arbitration and Conciliation Act have been amended. So have been removed. So the conciliation there is nothing but mediation here.
Right. So I think by virtue of an amendment in the other acts, in the schedules, the entire conciliation chapter has been removed, right?
Yes. Section 61 to 81, if I'm not wrong, but yes.
Yeah, I think it's time for the legislature to now re-nomenclate the Arbitration and Conciliation Act to Arbitration Act only, because conciliation has been taken care of. The name of conciliation has changed to mediation, is what you're saying. Right. Yeah, there may be a very, very thin line, I think, difference between conciliation and mediation, but I think for all practical purposes, this is what it is now, mediation.
I can also explain that thin line, maybe what you are referring to.
Yeah.
See, for conciliation, a conciliator sits and doesn't facilitate the complete settlement process. The conciliator will sit and the parties will then decide, and if they decide on reaching an amicable solution, then the conciliation is a successful conciliation. As far as the mediator is concerned, mediator pushes the parties to actually resolve the issues. So conciliator and mediator, this is the difference.
Yeah, although, it's slightly, counterintuitive also. Means if a conciliator sits and does not do anything, then why does he sit in the first place, on a lighter note. So I think good that conciliation has gone with that thin line difference, and mediation, which is more progressive, more proactive, where the mediator is supposed to be negotiating mediations, and nudging the parties to mediate. I think that's what is the essence. And I think the essence of this act, other than the ad hoc mediation or the mediation as a concept, one of the key things to me when I was reading it is the institutional mediation concept, which was not there at all. There was nothing called institutional conciliation, right?
Correct.
But now there is institutional mediation and a whole ecosystem of mediation service providers, mediators to be registered with the Mediation Council of India as a body, to have its chairman and executive body and, etc. under the government. So I think this is quite a welcome step to promote the whole concept of mediation, which is quite welcome. I'll just share, Varun, one of my experience. I was appearing in one of the district courts, and the matter was referred to the mediation center in that court with the consent of course, both the parties. And as you had said, they are not interested in the merits of the case at all. I mean, they don't even get into it. Their question is how much you are asking for and how much you are wanting to give, and why don't you just settle? Means I think the mediation happened so quickly because with the just the presence of a third party who is unbiased and who doesn't have any vested interest or no conflict of interest, and I think who nudges you, to sort of negotiate, to bend a little bit here and bend a little bit there. Mediations can be sort of forged, and I think with
Yes.
the increasing number of litigations, I think these alternative dispute resolutions are important, and if mediation really takes shape the way it is intended to, it will really be quite important in the ADR mechanism.
This is going to reduce a lot of load on the courts. Obviously, we have seen post COVID, the courts are now loaded with cases for pendencies are going on. And like I was, one of my colleagues was telling me, 2016 arguments are currently going on for consumer cases in Delhi. 2016, we are in 2023. So
Right.
yes, with this mediation coming in this legislation, this will actually reduce the load on the courts.
Yeah. So now, picking up the thread from there only, Varun, like if there is a mediation clause or a mediation agreement, can the parties directly approach the courts or initiate arbitrations, even if there's a mediation agreement or a clause?
See, we have seen in again drawing the conclusion from the Arbitration Act. I will say Arbitration Act only now. So yeah, so we have seen with the presence of the arbitration clause or an arbitration agreement, if you go to the court, there's always an objection, and there are plethora of judgments by the Supreme Court and the Honorable High Courts also, that in the presence of a arbitration clause or an arbitration agreement, the parties cannot directly approach the civil courts or any other court. Obviously, there are certain exemptions under which law the same cannot be done. But yes, as far as the mediation is concerned, I would say it will have the same meaning if the parties have resorted to have mediation under this Act, Mediation Act 2023. Then this will have the same effect as the arbitration, that first the parties should go through the process of mediating and see if there is a possibility for resolving the disputes amicably. In case the mediation fails, then the parties may resort to the litigation through regular courts or so.
Yeah. Although the Act is silent about it, but what you're saying is quite reasonable and logical, and maybe this jurisprudence develops as this Act is put to the courts, that if there is a clause, courts may surely direct the parties to first utilize the mediation mechanism and then only approach the courts. That's quite.
Otherwise, otherwise the requirement of adding this clause or putting it in the agreement is completely wasted.
Is wasted, and if that was the intent of the parties while putting the agreement, putting that clause, they might as well they should be complying with that. And otherwise, the objective of the whole mechanism will be defeated. Yeah, if they were to approach the court for the arbitration directly. So now, can parties have both the clauses, mediation clause and an arbitration clause in an agreement? I'm just splitting the hair, just so that some clarity emerges and this discussion becomes, quite a good, FAQs which might be there in people's minds.
I don't see a reason why there can't be both mediation and arbitration clause. I don't see a reason why it cannot be. However, again, the Act is completely silent. There is the jurisprudence is it has to develop now. So we don't know. However, it shouldn't be any problem, because the parties can first go for mediation, then go for arbitration, and then maybe regular courts.
Regular only, of course, with limited challenge, that is available in arbitration. Yeah.
Yes.
Okay. Now, what was I thinking? Can the counsels represent the parties in a mediation proceeding?
See, if we go by the definitions that have been given in the Act, the party is the party to the dispute, the two parties who are between whom the mediation proceedings are going on. And then there is a specific word that has been added, which is participants. So participants cover attorneys, advisors, nominees. And if I can just come to the definition itself. It is section 3R. It means advisors, advocates, consultants, and any technical experts and observers. So advocates are written here. So I believe, yes, for the mediation proceedings, then the advocates will be able to represent their parties.
Yeah, and not why just advocates. I'm both an advocate as well as also a company secretary. So I feel even the other professions like company secretaries in practice, or even chartered accountants who have been sort of litigating before IT or GST or other sort of tax,
Absolutely.
wherever,
Absolutely.
means all professionals should be able to sort of also represent their clients in the mediation proceedings, right?
Yes.
Well, the word used are advocates, advisors, consultants, and any technical experts and observers. Right. Unlike, again, there's some special acts like POSH Act, where in a POSH ICC committee proceeding, advocates are not allowed very specifically. So here, I think
Yes.
it's a settlement or a mediation, and even if there's a mediator, but still advocates and consultants and advisors can be there just to again facilitate the settlements.
Correct.
All right. Now, moving on the mediation proceedings. So coming to the jurisdiction is a big issue when we talk of arbitration or when we talk of the regular court proceedings as to which court will have the jurisdiction. So what is the concept of jurisdiction here in mediation?
Parties, as we do it in arbitration, parties can decide a specific. It's not necessary that mediation has to happen according to the addresses or the place of businesses of the parties. The parties can decide where they want to mediate. That is one. Second, it's online mediation has now been given. It's there in the act. So online mediation is there. It says it, and the place of business is there. The place of business of the parties is there. Section 13 talks about it. Section 13 talks about it. No, not Section 13.
Yeah, 13.
Section 13. Yeah, Section 13 talks about it. The shall be undertaken within the territorial jurisdiction of the court or tribunal competent jurisdiction to decide subject matter of the dispute. That is as per the CPC. Then, if the parties mutually decide to mediate at a place outside their jurisdiction, and then the online mediation. So that for the online mediation, again, the jurisdiction will be the court or the tribunal that is competent to decide the dispute.
Yeah, no, but online is online, right? Online can happen anywhere all across the country. What is territorial in an online thing?
For execution, if
it was to be breached, the settlement agreement is breached, then of course the territorial jurisdiction as per CPC or what the parties have decided. Yeah.
Yes.
Yes. But I think online is also good. And coming to CPC, since you mentioned CPC, so whether CPC as such applies to mediation proceedings?
No. Even as per Act, no. The Act says the CPC will not be applicable.
Right. But I think in a very limited way, as you said, the territorial jurisdiction is because the Section 13 says every mediation shall be taken within the territorial jurisdiction of the court or tribunal of competent jurisdiction, and that will derive its meaning from the CPC. So I think in limited aspects, CPC might be derived the interpretations, but overall, yes, you're right. Section 15(5) says the mediator shall not be bound by the Code of Civil Procedure or the Indian Evidence Act. Right. So which is also quite good, it being a new act and a baby act right now. For a baby to grow and take shape, if it was given a robe of a 100-year-old adult, it wouldn't have really grown the way it is expected to grow. So it is good that the robes of a 100-year-old CPC and the Evidence Act are not sort of imposed on the Mediation Act, and therefore it can develop its own procedures and processes and expedite with an intent to resolve. Yeah.
And the same thing also helps the mediator to be more free in their approach of helping the parties settle. They don't have to abide by a set rules and set principles. They can use their own techniques. They can use their own methods. So that is therefore.
Yeah, and I believe I think the timelines are also very, very important as far as mediation proceedings are concerned. Unlike courts, where of course all timelines are recommendatory and never mandatory, but here also certain timelines have been provided. So if you would like to address.
Yes, the timelines are 120 days plus 60 days. So 120 days is the time that has been given during which the mediation has to finish, and 60 days is the time that can be extended if both the parties agree.
You're right. So which is quite fast. 4 months for a settlement or the following 2 months. So at the outside 6 months for a settlement.
Yes.
What if the settlement fails, Varun? Timelines are good, settlements are good, but since everything is happening with the consent of both the parties, and these are the parties who are sort of fighting. So when parties fight, where is the consent? So what happens if the mediation agreements or sort of not agreements, where the mediation fails per se?
Sumit, it's a method of resolving dispute in an alternative way, because it's an ADR, right? So if the parties fail to resolve their dispute through mediation, then they will have to go to the courts, or as we discussed earlier, if they have arbitration in their agreement, then they'll go for arbitration.
Right.
If the mediation fails, then as per the act, the mediator has to submit a non-settlement proposal with the council or the mediation service provider. But that's a procedural thing. In general, if the parties fail to reach at an amicable solution through mediation, then they will have to resort to the regular jurisdiction of the court and the regular process of the court through CPC or any other specific dispute is.
Either the arbitration or the court, as the case may be. Yeah. Understand. And mediated settlement agreement, you mentioned it can be the execution proceedings can be launched. For that, is it required to be registered somewhere?
It's not mandatory. It can be registered. It's not mandatory. However, the rules have yet to come. Section 20 talks about it. It says may at an option of parties be registered with an authority constituted under the said act. So the authority constituted under the said act will be the Mediation Council of India. But however, the rules are still not out, and it says so it's not necessary, it's not mandatory that the mediated settlement agreements needs to be registered with the authority. Not necessary.
Right now, it doesn't look like, but as you rightly said, if the rules come out and some procedures are developed, and in case it emerges that registration is mandatory, let's see how the rules or the notifications come.
Yes.
Can mediation proceedings be challenged?
Mediation, the mediated settlement agreement arrived between the parties can be challenged on very limited grounds, like grounds of, I'll say, fraud, corruption, impersonation, or if the mediation was done for any kind of a dispute that has been barred under the first schedule. That's it. That's what the Section 28 states.
Yeah, so pretty much fraud and corruption are completely means outlier cases. So more like an undue what was that in the Indian Contract Act? Undue influence.
Undue influence.
So when the consent is not there by misrepresentation, under the Indian. So settlement agreement is also, it's like an agreement under the Indian Contract Act also. So I think those tenets of a contract have to be there. The consent has to be there, which is not obtained by fraud or undue influence or coercion, etc. I remember my law days 20 years back. And other than that, I think it's mostly maintainability to that extent, right? It means it can't be challenged on merits to that extent, what I'm hearing.
No, not at all. No. Merits, if parties once reach the settlement under the mediation and they sign the mediated settlement agreement, it becomes a judgment, as I stated earlier. It becomes a judgment under this act. So there are very, very limited grounds, and the grounds are, again, fraud, corruption, impersonation, or for the mediation for any dispute that has not been covered under that is not fit for mediation under first schedule of Section 6. Right. That's it. No merits.
Yeah. Okay. An interesting question. I think just like lawyers are used to fighting for maintainability, technical issues, I think another darling argument of lawyers is a limitation. If cases are barred by limitation, it's an easy win for the lawyers, for the arguing lawyer. So does the Limitation Act apply to mediations?
Again, jurisprudence still has to develop on this. However, the concept of Limitation Act comes from debt, the dues that have been barred by time, right? And if two parties, again, the basis of this act is consent by both the parties. If both parties mutually agree. So let's say if you and me have a debt which is time barred, and despite that we sit together and we sign an agreement, then the limitation continues from the date of the signing of the agreement. So application of Limitation Act is still in question, but yes, I can see if two parties decide to just simply extend the limitation period by signing the agreement, by agreeing, one party agreeing that the party will pay and clear the dues to the other party, then yes, I think it's not applicable then.
Yeah, in Hindi, on a lighter note, वो बोलते हैं ना, जब मियाँ बीवी राजी तो क्या करेगा काजी. So, both the parties are intending to settle. Why should the limitation come in between? But yes, on another note, if you suppose you were hypothetically required to pay me 1 lakh rupees, and that is 4 years old, which is time barred as per limitation, but you are most humbly and respectfully tendering by way of a settlement agreement, and I'm willing to accept it, then again, why should limitation bar you from paying and bar me from accepting, right? So therefore, limitation should not apply.
See, I am deriving this understanding from the fact that it doesn't really have to be like this mediated settlement agreement or anything. Even after 4 years, if I send you an email and say, okay, I will make the payment and something like that, and I acknowledge my debt, then also the limitation continues.
Yeah, that's there. But here the case, I was saying that if there's no acknowledgement as such, the debt is generally legally time barred. If you were to approach the courts, it is time barred. But then, if parties are submitting themselves to mediation, I don't know why. I mean, the errant party may understand that okay, it's not legally enforceable, so why to pay? But ethics is also something, and there may be some
highly
genuine,
unlikely.
not a loss of ethics, basically.
Yes, but it's highly unlikely. It's highly unlikely.
Okay. Now, I was reading somewhere in the law that the documentation which gets generated during the mediation or the conversation, etc., are very confidential, and none of it can be used as an evidence in the litigation. So, would you like to talk something about it?
Yes, there is a specific mention of confidentiality under the Act. So,
Yeah.
whatever that has been said, decided, talked, discussed during the mediation proceeding, that is all confidential. No party or the participants, as we discussed, parties are the ones who are deciding their disputes, and the participants are the people around them. So no one is allowed to disclose any kind of an information outside the mediation proceedings. The same can also not be used as an evidence in a court. You are not allowed to disclose it to anyone. Section 22 talks about the same, that any kind of an acknowledgement, opinion, suggestion, promises, they will be considered confidential. Acceptance or willingness to accept a proposal will be confidential. Documents prepared solely for the conduct of the mediation will be confidential, and any other mediation communication. So any other mediation communication covers every single thing.
Right. And I was also reading that even it is so confidential that even the proceedings cannot be recorded, right? Even if it's an mediation, no recording, audio, video, nothing of that sort can happen. It is that confidential.
Yes.
I think the only exception there could be the settlement agreement itself, because if the settlement agreement, mediated settlement agreement, if I may say so, is signed by both the parties, as you had said, it becomes a decree under the CPC. So then, if suppose the parties sign a mediated settlement agreement and then one of the parties backs out for some reason, so that I think is a proper evidence because execution proceedings are also possible against it. So that's a proper evidence once the agreement is signed and not before, and not anything leading to that, right?
Yes. And for that, there is an explanation for removal of doubt that has already been given here, because that comes in
the section 22.
Section 22 explanation. It is hereby clarified that nothing contained in this section shall apply to mediated settlement agreement, where its disclosure is necessary for the purpose of registration, obviously, enforcement, going for it, and challenge. So all the three scenarios are already covered under the Act, and out of these three, there is nothing for disclosing the mediation communication anywhere else is not allowed.
So only the question that I asked has been added as an explanation in the Act, and believe you me, it was not a crafted question. I genuinely did not read that explanation, but I'm happy that the question was nice. It deserved an explanation by the legislature. So thank you, legislature, for answering this question on behalf of Varun. Okay, now on the sometimes legal subjects become dry. Although I can see the attendees right there, constant. They are smiling as well, and they are quite attentive. I hope so, or I wish so, and that's why I see a constant number over there. So that's why Okay, online mediation, Varun, if you'd like to talk about online mediation, because that's a wonderful welcome step where the world is going online. So what is the governance around that?
We saw online mediation first in Consumer Protection Amendment 2019. And since then, this has become a very great step because it's easy. It's convenient. It's time saving. It's cost saving also. Online mediation, if parties decide to conduct a mediation through online mode, audio visual mode, and yes, when I say audio, you can have a mediation only on audio calls also. It is there in the section which specifically states it doesn't really need to be a video on video call. It can be an audio on audio call also, or a mix of both. So if parties decide to conduct mediation and go for mediation, again, consent is important. Again, so yeah, if parties decide to go for mediation through online mediums, through audiovisual mode, they can. This act allows them to conduct mediation. The mediator will be again either online or through any audiovisual attending through audiovisual equipment, and the mediation can happen. There are still regulations and rules are still required here because throughout the act only there is only one section that mentions about online mediation, and it's only four very small section. So I am assuming that further regulations and rules will come out to support the section, the procedure, and everything. The confidentiality, as we spoke about, the confidentiality is still there. The parties are not required to record the video, audio, or any kind of an online mediation proceeding. And the subsection 2 of section 30 in any case says that the process of online mediation shall be as in such manner as may be specified. So we are still awaiting for the rules and the regulations as may be specified.
Right. Thank you. Now this is 1 p.m. Taking sort of cognizance of the time. As I had promised, we'll finish by 1:30. So I see a plethora of questions, and thank you, audience, for giving so many queries and questions, which denotes your active interest and participation in the webinar. So Varun, you may have a voice rest for a couple of minutes, and you may want to glance through the questions in the meantime. Have a glass of water. In the meantime, I'd like to just take a 2-minute departure and tell you a little bit more about Complinity. Complinity, as I said, is India's leading compliance software, present in over 1,000, being used by over 1,000 plus companies and some 10,000 plus users from organizations like Panasonic, Max Hospital, Artemis Hospital, JP Group, Hero Group, Jai Bharat Maruti, Yes Bank, Razorpay, some PSUs, MNCs, listed companies, and any company essentially which is more than 100 crore top line, or if it's an MNC or a listed company or a PSU, they require a compliance software. And all the laws in the country are covered. Central laws, state laws, municipal regulations, all industry specific laws, be it liquor industry or a sugar industry or auto industry or BFSI, healthcare, pharmaceutical, etc., etc. So I'll request my team to play a small video on Complinity, and then we again come back to the Q&A session.
Welcome to Complinity Technologies. Complinity is India's leading governance, risk and compliance software helping companies to manage their compliance, contracts, litigation, legal updates, inter-financial controls and more. Complinity is a one-stop shop for all GRC needs. With our proprietary 12 GRC modules and real-time legal updates on 2,000 plus laws and 24,000 plus compliances, all in an integrated platform that is easy to use with automated alerts and risk management capabilities, is why compliance managers, general counsels and chief financial officers choose Complinity every time. Join the most innovative and prestigious brands that use Complinity. Automating your compliance management, request a demo at complinity.com. Welcome to Complinity Technology.
I'm sorry, I was on mute. Thank you, team, for telling me. I was saying, yeah, the questions are in front of you. You've anyway started answering. If you're using any compliance software, people on the employment side, and would you like to have a demo of Complinity compliance software? Okay, so anyways, you may continue doing that, and we can proceed to the Q&A box. And by the way, somebody was asking, will the recording of this session be available? Yes, the recording of this session will be available. However, you'll have to do a small thing. There are many links in the chat box. Choose the link which appeals to you most, which is please go to this first legal update section, put your email ID and confirm it so that you're notified on all the blogs and articles and videos and downloads which are uploaded to our website. Or else, or as a lawyer, I would say, please go and subscribe on the YouTube channel of Complinity or LinkedIn or Instagram or Facebook or Twitter. The top three are we are quite active on the top 3-4. But yes, of course, we are present on everyone. In fact, a podcast of this webinar will also be available on Spotify. The name is Compliance with Sumit. You could search for it, or you could simply click on this link, and you could hear it while. Why should you need to hear it, because you're anyways attending? But one of your friends could hear it while on their way from home to office or vice versa. Okay, so at least please click on one or two or a couple of more links as you are sort of getting the Q&A, because it'll be good to be connected through several means. Okay. Now coming to the questions, Varun, are you ready? I'll be launching a rapid fire now against you with all the audience questions.
Okay.
Yeah.
All right.
And if you do not know any answer, you can of course take that question back, and we can of course put it back through these mails or blogs or things like that. Yeah. Okay. Sure. Here I go. Does it provide only online mediation or offline as well? Means offline, of course, as well. So online and offline.
Yes.
So Varun, what I'll do is in tech industry it is called L1 support and L2 support. L1 is which a junior person can answer, and L2 is which goes to the experts. So the L1 support I'll give you, and the L2, of course, you can answer the questions which are slightly more technical. Okay, and anyway, sure. Since these questions came right at the starting of the webinar, a lot of these may have got clarified.
We have covered.
So in the interest of time, we have to finish at 1:30. I'll be going now fast. Okay, so okay, next is, there is already mediation laws as part of other laws. How this law is very different? How this law is different from others? Which one to prevail, Varun?
As I stated in the beginning, there are mediation laws in other acts and other legislations, but the process, it was required to be collated in one so that there is a complete process. Therefore, this act was enacted. Therefore, the legislature worked through so that they can make one single act covering all the disputes that can be mediated and with the same process.
Yeah, all right. Okay, how are international mediations covered?
But there are some gray areas with respect to international mediation. The international mediation definition is given. It's in section 2G. It says again the same kind of a dispute, commercial dispute between the parties agreeing to it. However, an individual who is a national or habitually resides in any country other than India is required to be there. And the process and procedure, we are still awaiting for it. So with the coming of rules and regulations, it will be more clear, specifically for international mediations. Right.
Now that was Juhi, by the way. So Karuna asks, what benefits would this Mediation Act will provide over the disputes being solved not arbitrarily, but maybe you want to mention through arbitration or arbitrarily. I don't know what's the intent of the question.
I'll take it as arbitration. I'll take it as arbitration, and as we have discussed,
arbitration only. Any comparative advantages in the act? So I think we have covered arbitration versus mediation, but any one line, Varun, you would like to say to this question?
Mediation will be cost effective. Mediation will be time effective. Arbitration takes more time. Plus, mediation parties will be free to discuss among themselves. Mediator will push the parties to settle instead, unlike arbitration, where it's more of a court where the arbitrator actually adjudicates the dispute. So it's more of like a free talk to settle the dispute than going to a court for adjudicating and fighting the matter.
Understand. Now, Juhi asks, what happens to the mediation under the Commercial Courts Act? It's indeed a very good question. And
It
Varun,
is. Yes, mediation, pre-litigation mediation under the Commercial Courts Act still remains. It's the manner and the method will be followed as per this act now. Section 5 covers rather pre-litigation mediation under the act, and it talks about subject to the other provisions whether any mediation agreement exists or not. The parties will be earlier the Commercial Courts Act Commercial Courts Act only pre-litigation mediation was there. Now it has been made given an option to the parties that any party who wants to come in case of any dispute can go for mediation. It doesn't really need to be under the Commercial Courts Act.
Yeah, so I think while the mediations will continue, but the rules and processes and little bit of governance around the mediation will be derived from this act under even if the mediation is under the Commercial Courts Act, right?
Yes.
Yeah. Now, Philip asks, are industrial disputes subject to mediation under the Act of 2023 when there is a specific settlement machinery provided, therefore, existing under the ID Act?
They have been excluded actually. ID Act has been excluded. There are few laws as per schedule, as per the second schedule. ID Act, Brahmaputra Road Act, Cine Workers and Cine Theatre Workers, Family Courts, Legal Service Authorities, Maintenance and Welfare of Parents and Senior Citizens, Sexual Harassment, as you rightly stated earlier, Finance Act and Industrial. These acts are not are the disputes where the Mediation Act will not be applicable.
Yeah, so 8-9 acts, out of which POSH comes out as a good one, Finance Act, which is like budget, and Industrial Dispute, Industrial Relations Code, and few others, as you said, Family Courts Act, etc. So they've been excluded and they will not be covered under the Mediation Act. Because of course, Philip, as you rightly said, since a specific machinery exists under those relevant laws, so therefore they will not be. But I'll ask a parallel question, Varun, around this. So NCLTs, as corporate lawyers, you have been appearing before NCLTs. Even I have done many hearings in my past job as an NCLT lawyer. So can NCLT also refer the shareholder, like in operation mismanagement cases, also to mediations under the Mediation Act?
Yes. There has been an amendment that has been made through Schedule 8, specifically in Section 442 of the Companies Act 2013, where now Mediation Act 2023 has now been added as a name, wherein parties for any kind of a dispute before the tribunal will be able to request the tribunal to pass the matter for mediation, or even if the parties don't do it, the tribunal on its own suo motu action can also send the matter for mediation under this act.
I'll ask you two counter questions related to this, and very fine print, I would say. Suppose, Varun, you are sort of arguing an operation mismanagement case in an NCLT, and now after passing of this act, can both the parties now, the dispute is 5 years old and it's under litigation for 5 years, can you now initiate mediation of course with the consent of both the parties for an old
mediation can be done. We can file an application, but not for under this act, because this has not come into force. The specific sections for which, because mediation council is yet to come into force, mediation service providers are not there, we don't have the empanelment of the mediators. But yes, as a general practice, you can approach the honorable tribunal with an application saying that there is a possibility for the resolution of the matter, and the judge will pass the order for and give the matter for mediation.
Yeah, no, I mean, of course, when parties are settling, dates do get fixed and adjourned if the parties are in settlement mode. However,
yes.
Assuming after the mediators get appointed under this act or empaneled, I would say, or mediation council gets established, then for an old dispute which has been there in NCLTs, can the mediation machinery can be exercised?
The act says no retrospective effect.
No, Varun, I think I would love to, not love to, but like to disagree with you a little bit. That I think my reading of the act says that if mediation was already initiated earlier, if there was some mediation happening earlier, it cannot be, this machinery cannot be used. But if the dispute is old, but the mediation was not initiated, then I think the mediation can be used. That's what.
So this is what I stated earlier when I said ki since the act is not in force yet, obviously once the act is in force, the parties will be able to go for the mediation under Mediation Act 2023.
Yeah, no, the fine print, Varun, what I'm trying to bring about here is that if suppose the act comes into force, say on 1st of November, just hypothetically, I'm saying, and you had initiated a mediation, not in this act, but otherwise, mediation was already running, then that mediation cannot be subject to the new act.
Yes, 100%. I actually, my apologies. I understood the question. I did not understood the question. I didn't understand the question.
But if the dispute is old, but the mediation is new, I mean, that mediation can still be mediated under the Mediation Act. Yeah.
Yes.
Okay. Now, question from Priyam. How will an ideal standard clause for mediation in commercial contracts look like? Any templates or reference?
We are in the process of actually drafting it. It's still in process. Yeah.
On a lighter note, copy the arbitration clause, control replace arbitration from mediation, and then look at the Arbitration Act and the Mediation Act and resolve for any sort of differences. That's on a lighter note. But yes, of course, these clauses would not be very technical. They'll be on the lines of arbitration, but with a few changes here and there. And they will emerge very, very soon as corporate lawyers who are attending this might already be drafting or might already have drafted the mediation clauses. And anyways, in my experience, as a lawyer, I've experienced, especially in the multinational contracts, MNC companies contracts, mediation clauses have always been there, even as a good governance or a good dispute resolution, even without this Mediation Act. Okay, Amitabh asks, we have filed many cases since 2022 in mediation and outcome result is good. My experience sharing. Thank you, Amitabh. I think that's quite a vote of confidence. One more, Amitabh says, once confirmation of memo filed, both the parties agree, it becomes a decree, which is very good for both the parties. Yes, it's not a question, but a comment, but thank you, Amitabh, for that comment. Sanmati says, will arbitration be done compulsorily if mediation fails? I think I'll answer that question, Varun, on your behalf. You can give a voice rest. That if mediation fails, the things go for litigation. Now, litigation could be either a normal court process or arbitration in case an arbitration was envisaged in the original agreement. So if your agreement says mediation, failing which arbitration, then it will go for arbitration. If your agreement says mediation, failing which jurisdiction of so-and-so courts will apply, then straight away you approach the courts. Right, Varun?
Yes, correct.
Yeah. Now, anonymous attendee, what is the binding nature of outcome of mediation?
It is binding on both the parties. As I said, if mediated settlement agreement will become a judgment, and there are only very limited grounds on which it can be challenged now.
Yeah, and an execution proceedings can be launched for a settlement agreement. So as I would like to reiterate what Varun said earlier during the webinar, that in case of a normal settlement agreement, if the consent terms are breached, then it's like a breach of contract and you go for a civil breach of contract or damages or whatever. But if a mediated settlement agreement under this act, negotiated or so not negotiated but facilitated by the mediator and signed by both the parties, then breach of that agreement, if there's a change of mind or change of circumstances, then straight away it's like a decree and execution proceedings can be launched against the defaulting party. Yeah. Okay. Sanmati says, should there be a mediation agreement compulsorily or simply a mediation clause in an agreement would suffice? I think the clause itself also would suffice. So we don't need a detailed mediation agreement. In fact, as we discussed in the webinar, that even if there is no agreement initially or a no clause initially, but when the parties dispute, and even at that time they agree to subject themselves to Mediation Act, they can do so. Even if it's an exchange of emails, at that time that, okay, we would like to go for mediation, the other party says, yes, we agree, and that can be treated like a mediation agreement or a clause or a...
Yeah.
Okay, Gagan Raj Purohit says, what is the exact purpose of the act? Quick resolution or out of court resolution? The former is contrary. It's quite a long question. Varun, you can read the question and answer.
Actually, I don't have the Q&A.
Oh, you don't have it? Okay. I'll read it for you then. Okay, so then generally it's a double blind. You are so innocent that all questions are coming. You haven't even read it, so that means it's real extempore answering. So good. I'll answer. I'll supplement the question. It says the former is contrary to the genesis of the Arbitration Act, which is quick resolution, or quick resolution was envisaged by way of arbitral proceeding. However, mediation dissolves the enforcement of law as the awards of mediation cannot be executed. So it's just an out of court. So frankly, pardon my ignorance, I didn't, maybe because of lack of time, did not understand the paragraph, but the first line is very clearly understood. Varun, whatever, if you could answer.
I'll have to read the question.
Okay,
Sumit,
so
that's what I'm saying. I don't have the question in front of me actually.
If you could answer, what is the exact purpose of the act? Quick resolution or out of court resolution?
Out of court resolution, obviously. Quick is a subset of the out of court resolution, because obviously it will be cost effective. It will be quick in nature. The parties will be free to discuss before a mediator their issues through which they want to settle, and the mediator will actually help to fast track the solving of the issue, reaching them an amicable settlement.
Yeah, so I think all out of court resolutions inherently should be quick resolutions, because of course out of court should be quicker than in courts, and
Yes.
of course it will be cost effective. So those are the clear benefits. Now somebody asks, can a plaintiff party file mediation against a defaulting party? What if the defaulting parties does not show interest in mediation, or they ignore this mediation settlement? No, so I would answer that question. It is not a case which you can file. Mediation can only be done with the consent of both the parties, not only referring to mediation, but also the settlement agreement itself, by definition, has to be with the consent of both the parties. So it's not like arbitration or a case where you can file it against a defaulting party, right? Okay, so Varun, supplement or me, or disagree with me wherever you feel like, if you think you need to sort of add anything. What are the practical implications of Mediation Act on businesses, especially FMCG business? So I don't think it has anything to do with the business per se. Any business, any industry, and mediation, whatever the procedures we have discussed, all those will apply. Survey says, is mediation agreement binding? Yes, we have already answered that question. It's binding. It can be launched as an execution decree. Means decree as an execution proceeding. Sarvesh again says, is settlement agreement binding through this side? I think it's a repetition. Difference between arbitration and mediation we have already covered. Mayank says, after reaching on a settlement agreement via mediation, can a party at a later stage challenge it, later date challenge it? To give the context, I'm drawing parallels with section 34 of the Arbitration and Conciliation Act. So challengeability of a settlement agreement.
Yes. The same. The mediated settlement agreement can be challenged, but only on a very limited grounds, as we discussed a few times during the webinar. Fraud, corruption, misrepresentation, or for the mediation has to be done for any dispute that was not covered, that should not be covered under the first schedule.
Right. Laura Rivers says, how can the agreement be enforceable in case one party does not fulfill? Is it possible to ratify it by a judge?
If the mediated settlement agreement has been signed by both the parties, then it becomes a judgment, and going through the execution proceedings will help, because through the now I can explain what execution proceedings are here.
No, I think in the interest of time we'll skip that. But yes, execution proceeding is to execute the decree. There are execution proceedings, so we leave it at that. But possible to ratify by a judge, Laura, I will say that the registration requirements of mediated settlement agreements right now, it's enabling provision has been given. The rules may give more details around that. So if mediated settlement agreements are registered, they may have some additional probably benefits of registration, etc. Maybe the execution becomes easier in that case.
Yes.
So that will remain to be seen once the rules are out. Now, a very good question, according to me. Kashmita says, can employment contracts or agreements include mediation clauses? Very, very apt, pertinent question. Varun, I'd like you to spend a minute on that.
So, Sumit, can
employment contracts or agreements, in like appointment letters or employment contracts, include mediation clauses now?
Yes, in my opinion, they should. Otherwise, the employment agreements in cases of termination and unlawful terminations, or an employee just going away and without serving the notice, there are employment issues that happen, and mediation clauses can actually help. Again, can help reduce load from the labor courts also. And as a process, as one of our viewers earlier suggested, when you go for the labor court, the first thing they do is they try to mediate, they try to conciliate the matter, they try to help the parties resolve. Only after that, the parties go for litigation. So as far as the employment agreements are concerned, uh, there has to the scope of the mediation, the scope of the mediation clause has to be seen, how broad it should be, because whether it's a mutual agreement, mutually drafted agreement, or it's a one-sided agreement. But yes, having a clause in the employment agreement is can actually help reduce load.
Understand. Anonymous question. We have arbitration clause in the agreement, so do we need to remove it and add mediation clause? Any option for us now to do that?
Well, not right now. If you already have an arbitration agreement, then you have already agreed to the fact that arbitration, you will, in case of any dispute, the parties will go for arbitration. And again, as I state again, the act doesn't say retrospective effect, doesn't come into retrospective effect. So if it comes into force, if the rules comes and say so maybe, but
No,
not yet.
I would like to add away, Varun, that suppose the parties are still in good terms and they would like to do an addendum and add a mediation clause. I don't think anything will stop them to add a mediation clause by way of an addendum, right? And also by way of an addendum, if they want to remove arbitration, although there is no need to, mediation and arbitration, as we discussed, can coexist. So because after, if the mediation fails, you need a dispute resolution either through court or through arbitration. So you can add a mediation clause through an addendum. If you need to remove arbitration for some reason, you may even do it in case both the parties are anyways agreeing to those addendums. But in that, you need to put a normal court process, which is not required. You can have mediation and arbitration both.
Yes, what I meant while answering was that adding a clause stating that mediation will happen as per Mediation Act 2023, because the act is the procedure and the process is yet to come into force, so it will not actually help the parties to add a mediation proceeding clause specific to this act. However, general mediation, yes, 100%.
Yeah. Okay. What does the new law say? Sanmati asks, what does the new law say on independence of mediator? Can a representative of one party act as a mediator? Of course, when both the parties agree.
There is a specific mention of disclosures that the mediator will have to put before the parties, and in case there is any connection with one of the parties, the mediator has to disclose it to the MSP or the council. And yes, the parties are given an option to waive off the conflict of interest. However, there is an option where you can the parties can waive off the conflict, but I don't think so it will, in practical purpose, it will happen.
Right. And you know, the line says, of course, if both the parties agree, that of course will not happen, because conflict of interest is a big thing as far as the Arbitration Act is concerned. Even under the Mediation Act, conflict of interest has to be taken care of, and therefore I think this is one of the biggest issues even in ad hoc arbitrations. But because when parties are disputing, they're not able to agree on a single name. You know, because one party may suspect a conflict of interest on the name proposed by the other party. So, and that's why people approach the courts first to get the arbitrator appointed, and which itself takes a lot of time. So I think and that's why the institutional arbitration, and in this case, institutional mediations, may be better to avoid the conflict of interest and bias, because those institutions will do conflict check, bias check as per their bylaws, rules, and processes. Okay. So Garima says, if CPC is not applicable, then how are we going for execution? So Garima, execution is specifically provided under the Act. When they say CPC is not applicable, they say mediator is not bound by the Code of Civil Procedure and the Indian Evidence Act, meaning he can fast track. There isn't a need of written statement, rejoinders, cross examinations, arguments. Straight away you can proceed, fast track the process. You don't need to go through all those evidence by way of affidavit and chief and this and that. However, execution has been specifically mentioned because they say that the mediated settlement agreement will be as good as a decree given by a court, which can be execution proceedings can be launched, right? Okay, next is Gagan says, if the parties have not decided on a seat of mediation. I'm happy to note this phrase, seat of mediation. You know, we have been seeing seat of arbitration.
Seat of arbitration.
The language of mediation, seat of mediation, etc., etc. For example, the mediation has been conducted online. Then where will the execution of mediation take place? Yes, Varun.
as per
Good question, I would say, first of all.
Yes, good question. The territorial jurisdiction where in the courts or the tribunal who have the regular jurisdiction to adjudicate the dispute in that court or on that tribunal, the execution proceedings will go.
Yeah. So even if it's online, but the for execution, the territorial jurisdiction as per the CPC will come back. Okay. Now Vivek Sundrial asks, can party withdraw from mediation process? Good question, Vivek.
Yes, parties can, at any point of time, parties can withdraw from mediation process. There is no compulsory requirement that you have to go through the complete process of mediation, because therefore there is a requirement where the parties may not reach at a settlement through the mediation. So one of those instances can be one of the parties don't feel to continue with the mediation anymore because of a deadlock or any kind of a situation. But yes, if any party can fall back from the mediation, withdraw from the mediation.
Vivek said after how many sessions? Of course, after any session. It could be after one session, it could be after 10 sessions. There's no such limit. Okay. Philip says, does a mediator under the Act of 2023 becomes functus officio once the proceedings are over and the mediation agreement is delivered or registered? So by functus officio, what I understand is defunct, is it? Will he become infructuous or defunct? What does functus officio mean?
Yes.
Yeah. So if that's what it means, I think, yes, if the mediation agreement is not mediation agreement, mediation settlement agreement, mediated settlement agreement. Because mediation agreement is different from a mediated settlement agreement. Mediation agreement would be when the parties are subjecting themselves to mediation. Mediated settlement agreement is towards the end when parties are settling. It's like a settlement agreement. So I think if the answer is this, if the question is second. Yes, my team wants to say something. Yes. Yeah. So I think my team is confirming my understanding of functus officio, means the duty of the officer is over. So yes, he would become functus officio after the mediated settlement agreement is signed. Unless Philip, unless the party again backtracks and execution proceedings are required. So mediator may not be able to represent the same party as an advocate, but then of course there are friends of those mediators who might be willing to do so. Okay. Okay. Now, let me hunt for more questions. Does Mediation Act have any provision in line with Section 9 of Arbitration Act?
Section 9 is
Yeah. Okay, we can or I'll ask my team to just quickly look at Section 9. Interim reliefs. Okay, Section 9 interim relief. So Mediation Act has any provision in line with interim reliefs? I don't think so. I didn't come across any interim reliefs or something.
Even I am not sure at this moment. I think it's a good question. We can check it.
Yeah. Sure, but I don't think, because it's not a judgment or it's not a relief. It is settlement, with mutual consent of both the parties. So I don't think the question of some relief, because interim relief also presupposes that there's an emergency. It is so urgent that the interim relief should be granted, so that it doesn't jeopardize the whole situation. So, and it is in favor of somebody and against somebody. But here everything is with mutual consent. So I don't think any interim relief is there.
Mediator will not be given the authority.
Debar also. I mean,
yes.
If mediator, in case some situations exist, and if both the parties are agreeing to certain interim measures, they can surely do some interim settlement agreement and then proceed for final settlement agreement, basically. Right? All this is not mentioned in the Act, but then these are the jurisprudence that will develop, or the practices and procedures that will come. Sana asks, any amount restriction, can we do mediation for 1 lakh also? Yes, I think there's no.
There is no limitation. There is no limit for any amount or anything that has come yet. Maybe through rules or regulation, it might just come, but it's not here, not in the Act. There is no baseline.
Yeah, Vishal says we are an NBFC, and as of now, we are having arbitration clause in our loan agreement. How adding mediation clause will help us, and whether it should be included? It's a good question. I think I'll attempt that. Yes, as an NBFC, I know the most important matters that you encounter is the recovery, delinquencies and recoveries, right? So having mediations may help. You may have named mediators because I've seen having named arbitrators also in NBFC cases. So named mediators, it can very quickly fast track, a nudge, tell the opposite party that if they do not sort of comply or pay the money back, the repercussions, etc. And other than that, also nudge them for settlements because I think that's the first step, anyways. And if they agree to a settlement agreement, which becomes a mediated settlement agreement, as it becomes a decree, which is straight away execution proceedings can be launched. So I think it can become a very, very powerful tool, I would say, Vishal. Not only means you should seriously consider putting mediation clauses, because if the parties are settling in the heat of the moment and it becomes a valid binding agreement, which is a decree, where straight away you can proceed for execution, I think it becomes a very powerful tool. Okay, MSME disputes, are they covered in that? Sarvesh asks. Yes, so yes. I think MSME Council has been subject to means the mediation that MSME Council was doing, that this act will be now applicable for the procedures and processes on that. Yeah. Okay, friends, it's 1:35. I hope you're enjoying the Q&A. There are a few more questions left. Varun, if you do not mind, can we extend by 7 more minutes and complete the questions?
Sure.
Audience, if you're also there, I know we are holding, between the lunch and between you and the lunch, but I think, some questions are unanswered. They're interesting questions. So you might as well stay. We'll finish in the next 5-7 minutes. So Astha says, what is the rationale for exclusion of industrial disputes, sine worker, etc., given commercial code has been amended to allow mediation? So she's saying commercial code has been amended to allow under this act, but then why industrial disputes would have been excluded?
The mechanism for mediation under commercial codes, they already have a process, pre-litigation mediation and the complete process. As far as the other laws that are now given, the disputes that arise out of them may not require such a detailed process of going through the complete mediation where a mediator has to be appointed. Not all disputes. We may see some kind of exceptions when the rules or regulations may come out. Specifically, if we talk about the Industrial Dispute Act, if it's a case of a union strike, then it may not help with the appointment of an appointment of a mediator to settle the matter, because as per the ID Act, they have a separate mechanism for resolving their disputes.
Yeah. All right. So one question is, mediation agreement is there in the agreement, mediation clause is there in the agreement. What if one party is not willing to go for mediation in case of a dispute under such an agreement? I think it's good. It's a very good question. The clause exists, but at the time of dispute, one party denies. Wonderful question, I would say. And it has set me thinking as well. Initially the party said yes, they will be subject to mediation, and now the party is sort of saying no, I will not, I do not want to. Varun, any thoughts?
Yes. See, if the mediator has been named, see, the most important thing that comes out of mediation is who will be mediating. So if the parties have already decided on one particular name, and then the party is not agreeing to go for mediation, then the mediator, then maybe breach of contracts can, again, starting of a mediation proceeding will only depend when both the parties sit there. But if the parties have not named any mediator, then it becomes a simple contractual issue only.
Yeah. And I think one very important point brought out by my team sitting in the same room, Vanchika, is that, thank you, Vanchika, for this idea, is that if there is a mediation clause in an agreement, and if you do not proceed for mediation, it may be challenged as a breach of contract because you're not complying with the terms of your agreement. However, the easier way for that party could be you proceed for mediation, but do not settle. I mean, do not deny the mediation, go for mediation, but then say, yeah, no, these terms are not acceptable, and simply walk out of that, because settlement cannot happen if both the parties agree. So if there's a mediation clause in an agreement, do not say I will not go for mediation. Go for mediation, but then do not settle, because nobody can force you to settle. So I think that will be a good way out for parties. Okay. Laura says, where can the agreement be registered? Again, the rules have to come out. So
yes.
Let's see what do the laws, what does the rules say about that? Can the mediator pass interim settlement agreement? Again, with consent of parties, as we said, if the there are no such provisions. But then, in case the situation or circumstances so demand, and if both the parties agree for some interim settlements, even when the final, for example, I'll give you an example. Suppose it's a case for recovery of say 2 crore rupees, right? And one party says no, according to us 1.5 crores is due, not 2 crores. And if both the parties agree that okay, can you give whatever you are agreeing to, it's like the courts also behave in the same way. If you're agreeing to paying 1.5 and he's asking for 2, let the dispute only be for 50 lakhs, and if you don't mind paying 1.5, and there may be an interim settlement agreement for 1.5 while the dispute for 50 lakh continues. So I think that could be a theoretical interim settlement agreement as well.
Sumit, I would like to add here. This is no longer an interim thing, because the act covers that it doesn't really require for parties to have a final settlement on the complete issue. The mediated settlement agreement can be for a part of the issue also, or for issues outside the main dispute. So if, as the example as you gave, for if it's 1.5, so 1.5 CR if it is given and the agreement is done, and 1.5 the parties have decided in what manner and how the money will come, the dispute only remains for 50, and the parties will litigate for 50 only. So the act provides for this.
Okay. Oh, that's quite nice. And so anyways, you are saying the act provides for means
Part settlement,
which could be interim settlements as well. Yeah, all right. Okay. Next is yes, Aswani asks, can a mediated settlement agreement override another mediated settlement agreement? Oh, quite an innovative question, I would say. Yeah.
A mediated settlement agreement, as I understand from the act, will be by one or more, or the set of arbitrators during one complete session of the mediation. And if it has to be superseded, if I heard correctly, Sumit, that was the word.
Yeah,
I don't have.
Can one mediated settlement agreement override another mediated settlement?
Override. So now, for having overriding effect, the earlier settlement agreement needs to have another mediation clause into it. So that's what I'm trying to understand, because otherwise overriding effect will not come on the mediated settlement agreement, because it will become a judgment.
Yeah, no, but Varun, there I would like to add that if both parties agree to one agreement, right, and then later, even before the execution proceedings are launched, I mean, suppose there is no backtracking, but then they decide to amend those terms, what they agreed, and suppose they say, okay, initially we decided, we'll pay you over the next 6 months, but based on subsequent conversations and understanding, we'll pay you 50% in 3 months. 75%, or 25% over the next 3 months, balance 25 in the following 3 months. So they want to change the terms of the earlier agreement. I think they should be able to do it, because that's the thing in any contract, right? Any subsequent consent of the parties can, of course, amend any agreement, and this agreement should be no exception as such. Yeah, with
maybe rules or regulations that will come out can further put some light on this issue.
Yeah, but I would say we don't even need rules, Varun. I'd beg to disagree over there, because Indian contract, it will be governed by Indian Contract Act also. Like, one mediated settlement agreement is contract number 1. The second mediated contract settlement agreement will become an addendum to contract number 1, because that's a subsequent wish of the parties to behave in a certain way. And I think if the parties are consenting, there shouldn't be any problem.
Okay.
Yeah. Okay. This I think we have discussed. Mediation clause is there in the agreement. What if one party is not willing to go for mediation? So we have discussed that. Do not backtrack, because it's a gray area. You may be held for a breach of contract. So therefore, go for it, but don't settle. I think that will be a easier or a erring on the side of caution. Okay. So let me now see if any other question is left. Gagan says, if no communication for mediation can be allowed to be disclosed, then how can that be a step for acknowledgement of debt, leading to increase in limitation period? Yeah, that's also a good question. However, Gagan, I will say that the interim emails or conversations cannot be produced as an evidence or an acknowledgement. However, if it's a mediated settlement agreement, which parties have signed and the mediator has sort of attested that or witnessed that, then that's a clear decree and also an acknowledgement of debt. Varun, if you'd like to add anything.
Yes, that's correct. That's because the mediated settlement agreement will not talk about the merits of the matter. Will not talk about the issues of between the parties. The mediated settlement agreement will only record the terms of the settlement.
Right. Okay, let me see if there's any other question left. Philip says, if for the purpose of challenging the mediation agreement, the proceedings culminating in mediation agreement can be disclosed, then what is the sanctity of confidentiality as regards mediation agreement is concerned?
Well, challenge is a right that is given under the Act, and you cannot, respectfully, you cannot stop anyone from challenging any award or a decree, because that's a right that has been given to you. So,
Yeah,
if for
and confidentiality does not mean that if there is an agreement and that is not being fulfilled by one party. Of course, for challenging, you'll have to produce the agreement before an execution court, and that does not mean you're compromising with the confidentiality. Yeah, to that extent. Just give me a second. Okay, I think we're almost done with the questions. So I think it was a wonderful session, Varun. Thank you very much for doing the session. To close the note or to close the webinar, I'd like you to give your closing remarks, Varun. According to you, will this mediation law succeed in India? What according to you are the opportunities and challenges for corporates as well as professionals? And then do you think that this Mediation Act is going to be a success in India?
Thank you, Sumit. The Act basically defines the time-bound procedure for conducting mediations in India, and including stipulations regarding timelines, mediators' appointment, setting up of councils, and the statutory authority. It also addresses the enforcement and challenge of domestic mediated settlement agreement. With the establishment of the body and with the coming up of mediation service providers, I think it will be a big opportunities for the lawyers, the other professionals to set up their entities. Definitely, this is a new concept. This is just like as initially you stated for insolvency and bank under the IBC, like creation of IPEs and everything. So yes, this is a very welcoming legislation and it will help save cost for the litigants. It will help save time. It will reduce load on the courts, and I believe it will good. If you ask me, in my personal opinion, it will be better than arbitration.
Let's hope so. Yes, with reduced procedures, reduced formalities, less expenses. Because when parties dispute, in my personal experience also, all they need is somebody neutral to be nudging them to settle. Because in the heart of the heart, even the litigating parties do not want to litigate. In the heart of the heart, everyone wants to settle. But of course, the settlement terms is something that requires intense negotiation. So I think the profession called mediators will now is expected to spring, where people who are good in negotiations, in building rapport and relationship with both the parties in an unbiased way, and who carry an attitude of win-win and not win-lose, or means I win, you lose, or you lose means you win, I lose. If somebody, the best negotiations are which can be win-win, where both parties walk out happily, saying, it was a great negotiation. And I think I would like to also end here this webinar with a quote by Mahatma Gandhi, who was also a lawyer, as you all know. He said, a good lawyer is not one who makes parties litigate. In fact, he's the one who makes parties settle. So I think the best job or service that an advocate or a lawyer, and now in this context, even a professional company secretary, chartered accountant, cost and management accountant, or any other professional can execute is in making parties settle. I think by doing this, we will be reducing the burden of more than 5 crore cases which are languishing in Indian courts, which takes anywhere between couple of years to 10, 15, 20 years, primary jurisdiction, then appeals, then further appeals, etc., etc. I think it's a wonderful step in that direction, so that parties get justice at the earliest, the cost of litigation is reduced, and the overall economics and the business ecosystem in India flourishes with lesser disputes, faster resolutions. So on that note, I think it was a wonderful webinar, Varun, in my opinion. I hope the audience also enjoyed it. And to the audience, please subscribe to all the links or one or more of the links that have been given in the chat boxes. A recording of this webinar will be available and will be notified to you. Keep coming out with more webinars, and if there's any suggestion on the topic, please do write to us through any channel, and we'll be happy to bring experts. And as you have noticed, the intent of Complinity is not to bring very high profile dignitaries to webinars. It is to bring practicing professionals who have hands-on experience on certain things, on subject matters, so that it's more like a workshop, like a master class, so that we can uncover certain aspects, answer questions properly with due attention and time. And I hope we have been able to answer most of the questions that were posed. So thank you, Varun, for a wonderful presentation.
Thank you so much, Sumit.
Yeah,
thank you very much.
Enjoyed the session, and I hope the audience also enjoyed. And thanks, team. Thanks the eMinds legal team for doing all the research work. Thanks the Complinity team for putting all the logistics and the tech together. Thank you very much. Bye.
Welcome to Complinity Technologies. Complinity is India's leading governance, risk and compliance software helping companies to manage their compliance, contracts, litigation, legal updates, inter-financial controls and more. Complinity is a one-stop shop for all GRC needs. With our proprietary 12 GRC modules and real-time legal updates on 2,000+ laws and 24,000+ compliances, all in an integrated platform that is easy to use with automated alerts and risk management capabilities, is why compliance managers, general counsels and chief financial officers choose Complinity every time. Join the most innovative and prestigious brands that use Complinity. Automating your compliance management. Request a demo at complinity.com.